Welcome, everybody. Or rather, welcome me back to the United States of America. Right in the middle of this government shutdown thing. It is a really complicated topic, and I'm going to avoid a little bit of the politics here and try to keep this center of the bell curve, if such a thing even exists. There is a lawsuit in the United States Court of Federal Claims, Albert Vieira versus United States of America, and it goes like this. A partial government shutdown affecting several federal agencies providing critical services to the American public has been in effect since December 22nd, 2018. Hundreds of thousands of federal employees, including tens of thousands of National Treasury Employees Union members, are accepted employees who are being forced to work during the partial government shutdown without pay. The compensation for overtime worked on December 22nd, the first day of the shutdown, was not paid on time. It is, moreover, unknown when they will be paid for that work and for work performed since that date. This is a collective action lawsuit brought by Albert Vieira on behalf of himself and all similarly situated individuals. The complaint makes two central allegations. First, it alleges that the government's failure to timely pay overtime wages earned on December 22, 2018 to Fair Labor Standards Act non-exempt employees like Mr. Vieira is illegal. Second, the complaint further alleges an FLSA violation based upon the expected government failure to pay a minimum wage and overtime wages earned for a pay period beginning December 23, 2018 and ending on January 5, 2019. He seeks payment of the owed wages and an equal amount of liquidated damages and other appropriate remedies. This is really the interesting part here, because the way this government shutdown thing is operating, there's going to be eventual compensation for these employees, but now there's going to be additional damages in the form of these Fair Labor Standards Act violations, which add 2 or 3 times to the amount owed. So if this works out in these employees' favor, they're going to get paid for the work plus damages on top of that, which sound actually kind of reasonable to me, as they currently have to figure out all this extra stuff, how to pay for their mortgage or how to pay for whatever. 56% of Americans, something like that, live from paycheck to paycheck and really aren't going to survive very much further than another paycheck. So they need help, relief, and sometimes all we have is monetary relief under the law. And that is what the union representative is asking for here. We will skip jurisdiction and venue, but the purpose of the Court of Federal Claims is to bring these kinds of monetary claims against the United States. And as we've discussed before, the United States is sovereign, so it can deny a lawsuit against the United States. However, it in this case has given permission for a lawsuit under a law that says that you can file a sort of claim for this kind of violation. So Mr. Vieira is an employee of the Department of Homeland Security, Customs and Border Protection, and is a Customs and Border Protection officer. He is classified as non-exempt, and he has been classified as such throughout the partial government shutdown at issue. On November 25th, he was deployed by CBP to the southwest border as part of the agency-wide initiative to combat illegal immigration. So he is a CBP officer that combats illegal immigration. He has worked in San Ysidro and Otay Mesa, California. His deployment is scheduled to last until January 13th, 2019. Like many other CBP employees, he is covered by both the Fair Labor Standards Act and other federal pay statutes, the Customs Officer Pay Reform Act, COPRA, which sets his overtime rate. Plaintiff Vieira's statutory right to the on-time payment of overtime wages earned, wages paid at the rate COPRA sets, is governed by the FLSA. As Section 216B of the FLSA requires, Plaintiff Vieira has given his written consent to be a party plaintiff in this action. The FLSA guarantees for employees falling within its coverage the on-time payment of any minimum wage or overtime wages earned. If those wages are earned but not paid out on the employee's corresponding regularly scheduled payday, the FLSA has been violated. The Act's timely payment requirement persists during a lapse in appropriated funds. And they quote a Ninth Circuit case and a federal claims case. On December 22nd, 2018, at 12:01 a.m., a partial government shutdown began. It remains in effect. Among several other federal agencies, the shutdown implicates Plaintiff Vieira's agency employer, the Department of Homeland Security. The Anti-Deficiency Act authorizes the executive branch to require employees to work without pay during a lapse in appropriated funds if their work relates to the safety or human life or the protection of property. Employees designated to work during a lapse in appropriated funds are deemed accepted employees. Each federal agency employee, for purposes of a shutdown, is classified as either accepted or non-accepted. Plaintiff Vieira was designated an accepted employee for the shutdown that began on December 22nd. On December 22nd, Mr. Vieira worked a 12-hour overtime assignment. He should have been paid for that work, but was not by either December 31st, the date on which the electronic funds transfer wage payments for the pay period encompassing December 22nd issued, or by January 3rd, the date on which paper checks for the pay period encompassing December 22nd issued. Because it is unknown when Congress will fund Plaintiff Vieira's employing agency, it is unknown when he will be paid for the overtime work that he performed on December 22nd. What is known, however, is that the payment is past due. The federal government's failure to pay Plaintiff Vieira and other FLSA non-exempt accepted employees who performed overtime work on December 22nd on time violated the FLSA. The federal government was on notice, including from previous litigation, that a failure to pay FLSA non-exempt employees their overtime wages on time, regardless of whether the government is shut down, is a per se violation. The federal government, therefore, neither acted in good faith nor had reasonable grounds for believing that failure to pay FLSA non-exempt employees their overtime wages on time was compliant with the FLSA. Plaintiff Vieira and similarly situated employees are thus entitled under the FLSA to the payment of their overtime wages earned on December 22nd and the payment of liquidated damages equal to that now late payment of overtime wages. Plaintiff Vieira works 6 days a week. He has worked 6 days a week during the instant shutdown. That work includes non-overtime and overtime work. He is scheduled to be paid wages earned between December 23rd, 2018 and January 5th, 2019 on either January 14th, the date on which EFT wage payments for that pay period are due, or by January 17th, the date on which the paper checks for that pay period are due. Are we getting this? John Michael Mulvaney is the president's acting chief of staff. Mr. Mulvaney stated on January 6, 2019, that if there is no agreement to end the shutdown by midnight on Tuesday, January 8th, 2019, then payroll will not go out as originally planned on Friday night. And they cite to a Huffington Post article. It is substantially likely that the shutdown will go beyond midnight on Tuesday, January 8th, which makes it substantially likely that Mr. Vieira will not receive any wages for work that he performed from January 23rd through January 5th on his regularly scheduled payday, etc. Mr. Vieira's failure to receive any pay constitutes 2 FLSA violations. He will not have been timely paid a minimum wage for his regular hours worked, violating the minimum wage provision. Further, he will not have been paid any overtime wages earned during this period, violating the overtime provision. The federal government has previously been held to be liable for liquidated damages stemming from its failure to timely pay FLSA wages to FLSA non-exempt employees during a government shutdown. That liability followed a ruling in Martin v. United States in 2017, a federal claims court case that the federal government failed to ascertain its FLSA obligations in connection with the payment of FLSA non-exempt accepted employees during a government shutdown. Nothing in the public domain indicates that since the Martin decision and prior to the instant shutdown, the government sought to obtain such an opinion or analysis. The FLSA overtime pay owed to Plaintiff Vieira, as well as the liquidated damages owed to him, may be paid from the Judgment Fund, which is a permanent appropriation for the payment of judgments and compromises. It is not subject to the annual appropriations process, and it is not implicated by the current shutdown. Oh, so that's interesting. So I'd have to look into what that is. The Judgment Fund 31 USC 1304 apparently is a permanent appropriation, does not need a current appropriation from the current Congress or approved budget or anything like that. So that's interesting if that's true and how that works. It is possible to have sort of a class action, but not as a class. It's more as a representative of a group. In this case, the union leader is representing the union, and they've chosen Plaintiff Vieira as the collective action representative. So it's very similar to a class, but instead of automatically encompassing everyone within a class, the category of people is less of a class action and more of a collective group, like a union or a church or religious movement or something like that. So you could see a pastor suing on behalf of his parishioners or something like that. That could be a collective action as well. A doctor suing on behalf of their patients would be a collective action. These things can also be class actions, just depends on how the plaintiff asks for the court to recognize it and meeting those requirements. Defendant, United States of America, failed to pay FLSA non-exempt accepted employees who worked overtime, etc. These employees suffered the same legal violation under the same factual circumstances and seek the same remedies. Defendant, United States of America, is substantially unlikely to pay them any wage whatsoever on their regularly scheduled payday. These employees will suffer the same legal violation. So they're making the case that they're all the same. They're all suffering the same damage. They all require the same remedy, and it can easily be put into a remedy that a court will be able to enforce. So cause of action 1 is the failure to pay overtime wages. 2 is failure to pay a minimum wage, and the request for relief. Order them to make the minimum payments. Order liquidated damages in an amount equal to any minimum wage and overtime wages. So that could be 2 or 3 times. I'm not sure whether that's looking for a doubling or trebling of damages. And any costs and fees and any further such relief. And of course, that's Greg O'Duden, National Treasury Employees Union, General Counsel. So that's very interesting. And there's some sort of appropriation, permanent appropriation. Let's see if we can look that up. 31 USC 1304. Necessary amounts are appropriated to pay final judgments, awards, compromise settlements, and interest and costs specified in the judgments or otherwise authorized by law when payment is not otherwise provided for. Payment is certified by the Secretary of Treasury. The judgment, award, or settlement is payable under these other sections. Yeah, United States Court of Federal Claims. So that looks like, yes, under 2517, this is a permanent appropriation that can pay out. So that's super interesting. And let's not talk any further about the politics behind the government shutdown. Okay, what the heck? The patron panel hasn't been on this whole time? I literally just put it up. So what do you think of that? If you are a federal employee and you are subject to this, you might consider asking your attorney about this kind of lawsuit and going after a doubling or trebling of your damages and asking for the court to order the payment out of the permanent appropriation fund. Now, there's a few things going on here, though. Does this mean that a court is going to be able to order that the federal employees can be automatically paid out of this permanent appropriation fund during the government shutdown? Possibly not. A lot of courts and court systems are shutting down as they are literally running out of money, and they aren't going to be able to operate without either emergency appropriations or someone working pretty much for free. So it's a very complicated situation. I'm just getting back from holiday. I have a bunch of stuff due in court, and I'm going to be focusing on my copyright responsibilities in court. And so this is something that's very important, that we pay attention to even the politics surrounding all of this, and let your Congress people know, let your representatives and senators and everybody know what you think. Call them, write them. If somebody could set up a robocall system so we could just all leave messages for them the same way they leave messages for us, yeah, that's going to work, solve the problem. We need to find a better way to have political discourse, especially with things like YouTube wanting to be more or less controversial, and therefore it's harder to have discussions about real things then, isn't it? So anyway, what do you think of all of that? Do you think it's right that we should be paying federal employees 2 or 3 times their missed wages? Would you want 2 or 3 times your missed wages if you didn't get paid and had to go begging various institutions and lenders and landlords and things for more time to pay, and hoping that they're gracious enough and that they don't owe money that they have, if they feel pressure and then want to pass that pressure on to you? This is a really complicated situation. So it's really important, if you feel in a way about this, that you let the appropriate parties know how you feel and what you think about it. What do you think the consequences of that are going to be for us lawyers? Are there going to be a bunch of lawyers who now want to help people file these federal claims because they can get their costs and damages paid for? Let's see. Maybe we know a few federal employees who have had to work but missed their paycheck and might be a potential plaintiff in one of these things. So anyway, thank you for joining me. Leave your thoughts in the comments below. Thank you for all of you who are supporting our channel, especially Patreon supporters Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, and Daniel Perez, all supporting our channel at the $50 level. And thank you very much to the $5 plus supporters who were supposed to be scrolling on the patron panel, but somehow it turned itself off after I turned it on. And you're scrolling on the screen, and I got you on now, and I'm really sorry about that, and we'll get you for the next time. So thank you very much. Here's some video outro of the dogs. Ilsa is doing really well. She had her x-ray on Tuesday, and the doctor said she is healing beautifully, and so she's almost back to normal. It's been about a year since she hurt her legs, so thank you so very much for your support and your love and everything. It has been a wonderful ride, and I'm looking forward to 2019. Love you all. Bye. That girl. I am here with my friends and we're dancing. We can feel all the obstacles go away. That's how we play. With your shaved butt. Be careful with the teeth and frozen balls. Drop. Where are you looking at? What? Squirrel? Found a squirrel? Yeah.